So we just went from the sublime, the immaculate, the pristine origin of our people and the continuity of the place where some of us may be lucky enough to return, or our children or grandchildren. What I want to say is at first blush what Matthew and Thaddeus are talking about may seem to be different worlds, but they're not. I'll tell you why they're not. I'll try to tell you why they're not. Experiences, again, comparing to others who have suffered genocide and crimes against humanity. As we know, and it's been said, it's been written, you've written it yourself. You've read it yourself. It happened on our homeland. The homeland was taken from us. And almost every other example of crimes against humanity is not quite that. This was deep. It hurts. And I think that's really the reason why, one of the reasons why we're here still, 100 years later. It was, we may not even consciously be able to think about it. I think it's in you. I think it's in us. I don't think it's something that you process, but there's a connection to it, the insights that Matthew's giving us. The bridge, I think, between the two worlds, that Matthew on the one hand now introduced us to, and the more specific that Thaddeus is going to walk us down that path. It's not unprecedented in the Armenian litigation experience. It's a misnomer, Armenian litigation experience, but not, just 10 years ago there was a case, and it was the prelacy, Armenian church prelacy, against the Getty Center. That's about the only real analogous, relevant example there is, that from this earth, from these churches, from these homes, there were antiquities, there were pieces of art, and they're now housed in Baltimore, they're now housed in Philadelphia, and they're now housed in Washington, D.C., and in Jerusalem, and in New York. They're there. The only thing that really has hit the radar screen was that lawsuit about 10 years ago, where a rare illuminated manuscript, the 13th century, by the genius Armenian illustrator Taurus Roslin, ended up in the hands, with proper provenance, so the story went, at the Getty Center up on Mulholland Drive. And there was a lawsuit, and there was a resolution, and without really delving into those details, all I'm saying is that there's a door opening there. There's something there to be had. We've talked amongst ourselves about those possibilities. Whether they be, Steve, for example, not singling out, in our families, there are Bibles, there are photos, there are paintings that we know of that were separated from us, like the Taurus Roslin 7 or 8 pages. Let's think about them, do some research. Thaddeus is going to give us a whole new perspective about what he does in terms of the litigation and the preservation and the provenance of art. We're very, very lucky to have Thaddeus Stauber come join us.
I come to you today very humble. Humbled at the request that you offered to come and share and speak with you. My objective here today is not to in any way demean or question the rights or the validity of any claims that you may be seeking to pursue individually or on behalf of the Armenian people. I come here as a technician. I come here as a practitioner. The name Thaddeus, I was very fortunate to have a very devout mother who raised 9 children, 7 boys. Thaddeus comes from the First Testament. St. Jude Thaddeus, the patron saint of lost causes. So, I don't know, maybe by definition from what I've heard, I'm in the right place. I'm very very moved by the presentation. Sign me up. I started my career as a public defender. I have tried and defended all nature of cases, including death penalty cases in Alabama. My grandfather was a union organizer. I went to law school by working in the Teamsters Union. I believe in the U.S. legal system. I believe that excellent advocacy, done well, by masters of their craft, can obtain the results that you're looking for. When an institution, a country, an individual honors me with a request to be their counsel, what I tell them from the start is I will seek the truth of the provenance and the background and the facts. The treks that were made to your homeland is exactly what I do when a case comes into me. I've had the fortune to travel to Switzerland, to Austria, to Germany. I've been digging in archives. Okay? To win these cases, you have got to get your hands on it. Throw your computers away. Get off your online research. Right? Get into the history. But first and foremost, work with counsel that knows how to create a roadmap to get you where you want to go down the winding path. We talked about the highlands, and if you don't mind, I'm going to actually come down into the weeds with you. Because what I've experienced is you don't win the cases talking about policy up here. Okay? That's what your public relations, that's what your advocacy, that's what your people in Washington, D.C., that's what your people at the UN do. Okay? That's not what you do as a trial lawyer. What you do is you have Irene be your associate. Okay? Irene is Armenian. Okay? There's a fight in her that I get the opportunity to utilize in my work. And what I'm going to try to do is I'm going to give you 5 or 6 cases that I've had the fortune of working through the last 20 years. They all demonstrate a different point of law that I utilize to beat you. Okay? Make no mistake, my job is solely and singly to beat you. When you choose to go into a court of law, or I take you into the court of law because you will not let go of what we do not think is a valid claim, the conversation is over. Right? This is an example. According to the review of Hans Reichel from 1910. It's a stunning work of German expressionism. Professor Peter Solz first spoke about it in 1956. He was a professor at the University of Berkeley when he did his seminal book on German expressionism. This artwork came out of Austria during World War II. It was owned by Dr. Reich, who had commissioned the work from Oscar Kokoschka. My client lives in New Orleans, Louisiana. My client's grandmother purchased this artwork in New York from a gallery after World War II. She then kept it. When her mother died, she donated works to the Boston Museum of Fine Arts, one work, and this work to her daughter. Her daughter brought it down to Louisiana and kept it in a home in the Garden District. When I came into the case, they did not know the circumstances from how it had gotten out of Austria. Okay? I went to Vienna. I went to the city museum and the city archives. I hired the local researcher, and we dug out the transaction documents from Dr. Reichel, who sold it to Otto Kallir. Otto Kallir at Gallery St. Etienne. You can still find it today. It's in New York City on 57th Street. It's run by his granddaughter, Jane Kallir. That took me to Jane Kallir in New York. Through Jane Kallir in New York, I found the receipt of Otto Kallir taking this work out of Vienna, taking it to Paris, bringing it to New York City during the war, selling it to my client, and sending the money back to Dr. Kalir. I'm sorry, Dr. Reichel. Okay, we presented that evidence to the claimant's family. They said that doesn't matter. It was a forced sale. Would never have sold it, but for the circumstances of the Holocaust coming to Austria. My client didn't see it that way, so we filed suit in Louisiana preemptively. Why did we do that? Because Louisiana has the Napoleonic Code. And under the Napoleonic Code, if I could establish that work of art was in Louisiana for a period of, I forget now, 7 or 10 years, and then my client held it as the owner, didn't have to publish it, didn't have to display it, you didn't need to know it was there, she just held herself out as the owner. Case is over. Okay. We won. Case dismissed, my client gets to keep the payment. They appealed it. Okay. That goes to the Fifth Circuit. We draw, the Fifth Circuit includes Texas. I draw 2 judges from Texas and 1 judge from Louisiana. The lawyers on the plaintiff's side are from Washington, D.C. and New York City. They come into the Fifth Circuit, and their opening argument is, Your Honors, under New York law. Wait a minute, stop right there. Did you take a plane to get here? Yes, Your Honor, I did. Where did you get on the plane? Got on it, and, that's all it's here. Did you spend any time in the law library here in Louisiana? No, Your Honor. The next words out of your mouth will be citing Louisiana law. Oh, but Your Honor, there's a federal common law. You're done arguing. Mr. Stauber, do you have anything to say? No, Your Honor, I'm good. The point here is, before you go into court or before you come after me, understand, I'm going to use the jurisdiction that is to my advantage. And you can talk to me all day long about what you think is the moral imperative. I do not think morality and law are 2 separate pillars. Okay? I think our laws have been written with moral underpinnings, with policy underpinnings. This is another example now of a very recent case that we did for the University of Oklahoma. This painting was purchased, again, following World War II, from a New York gallery by a prominent family, a Jewish family in Oklahoma, the Weissenhofer family. When Mrs. Weissenhofer passed away, she donated her art collection to the Fred Jones Jr. Museum at the University of Oklahoma. The University of Oklahoma, about 5-6 years ago, gets a letter. Gets a letter from Leona Meyer. Leona Meyer is a descendant of one of the families in Paris that started the Galerie Lafayette. A beautiful Galerie Lafayette. She's one of the wealthiest people in the country of France. Her lawyers write to the University of Oklahoma and say, Shepherd's bringing in a sheep was in my father's collection, was lost during the war. Says nothing more than that. Okay. Does not have the wisdom to try to engage in a dialogue with the University of Oklahoma. Simply files suit in the Southern District of New York. I get brought in just before the suit gets filed. I reach out to the plaintiff's counsel and I say, hold on. If you would like to have a conversation with us, you need to let me catch up. What do you know? What are your facts? You should know all this. We don't know. Okay, this work was donated to us. My institution is a public institution. It is completely transparent. We will share with you what we have. We will share with you what we find. But if you file suit, the conversation is over. They filed suit in the Southern District of New York. Okay? The University of Oklahoma is what? The agency instrumentality of the state of Oklahoma. The state of Oklahoma is what? It's got sovereign immunity. You cannot take me into the Southern District of New York. Okay? You can talk to me all day about the merits of your case, but I'm not going to fight it in the Southern District of New York. Now, you might think you have sympathetic judges there, but you've got some of the best practitioners of law sitting on that bench in the Southern District of New York. Okay? They've got plenty of cases to do. And they're going to go fast, and they're going to move, and they're going to respect good lawyering, and they're going to expect good lawyering. Okay? So we immediately come in, we move for dismissal, and we win. Okay? The case gets moved out of the Southern District of New York, the plaintiff appeals to the Second Circuit. Now, at the same time we're doing that, I get my butt on a plane, and I get to Switzerland. Why Switzerland? Well, what we found out from starting to scratch under the surface is that Leona Meyer's father, yes, in fact, had owned this artwork. Yes, it had been taken. But after the war, he had located in Switzerland. And he had brought a lawsuit in Switzerland against the current owner. The current owner was married to a Jewish woman. The current owner said, through exchanges of correspondence, I'd like to work out a resolution with you. I just don't want a loss for what I paid for it. They refused to have any negotiations, brought the lawsuit, and under Swiss law, at the time, the then owner was declared the valid owner. Case closed. Put away in a file. Not online. Can't go onto your, central filing system and find it. I hired a lawyer who's a professor at the University in Geneva, who's well into his 90s. He does the kind of archival research we talked about here. He finds for me the judgment from 1951. They still do it old school in Switzerland. They put a blue stamp on it. We bring that back physically to the United States. We say to the plaintiff, look, your mother settled this, your father had an opportunity, chose not to settle the case under Swiss law. Not only does the case not belong to the District of Europe, but we actually are going to enforce the judgment. And we're going to have it recognized in federal court in Oklahoma. But the case ends up getting transferred to Oklahoma. The Second Circuit doesn't take oral argument on the case. We fought like heck to have them dismiss, to just affirm the dismissal. They saw what we were doing, because if they had affirmed the dismissal without transferring the case, a little thing called the relation back period, okay? The time in which they filed their suit in New York would not have been recognized. You'd had a new filing date in Oklahoma. You would have been outside the statute of limitations. So now I'm going to get you on statute of limitations in addition to enforcing a foreign judgment. Second Circuit saw that, even though the plaintiffs didn't figure it out, en-rounded me, sent the case back to the judge with directions to transfer. Okay. You get a little help from the courts sometimes because you're sympathetic to your case. But I then take the case and we file the Swiss judgment in Oklahoma court, and I'm keeping the pressure on. And at this point, the plaintiffs say, let's talk. And in fact, not just the plaintiffs, but the World Jewish Congress, which advocates these cases, says, let's talk. Because they don't want an adverse judgment. They don't want a ruling that will enforce a Swiss judgment. Okay? So we end up in a healthy negotiation. Very, very honored and pleased to say that ultimately we resolved the case with something that I offered right from the start to them, which is the University of Oklahoma is a public institution. Its job is to educate, build bridges, it doesn't have a financial value to us. We don't put it on our books. You won't find it on an asset. We have insurance on it, but that's not the purpose of it once it comes into our institution. So we wanted to build a bridge with Paris, with the great institutions in Paris. And so the work now can be seen at the Musée d'Orsay with a plaque talking about the history of it, honoring all of the owners in the path, acknowledging their good faith. It will stay at the Musée d'Orsay for another 4 years. Then it will come back to the University of Oklahoma for 3 years, and it will go back and forth between France and the University of Oklahoma in perpetuity. Okay. Thank you. So there we see utilization of a foreign judgment, prior action. I'm going to bring that to the United States and enforce it. Portrait of Greta Mole. Kind of a theme here with portraits. This was commissioned by Greta Mole and her husband in 1908 directly with the artist Henri Matisse. This painting is at the National Gallery in London. You can see it there today. It was acquired in 1976 by the National Gallery of London. The National Gallery of London is an agency or instrumentality of the United Kingdom. In this particular case, the plaintiffs, who are the heirs of Greta Mole, decided to try to bootleg on to World War II claims and say that this painting, which we acknowledge was owned by Greta Mole and her husband, they said that their family survived the war, not Jewish, but with the fallout in Eastern and Western Europe, right after the war, the Russians taking property, that they gave it to a family friend who took it to Switzerland, was supposed to place it for sale or safekeeping, instead sold it and took the money. I don't know that that is true or isn't true. And it's not documented anywhere. This is just what the story that they told. They first brought the case in the United Kingdom, attempting to use the spoliation panel. The spoliation panel in the UK was set up in response to Holocaust-related claims, because in the UK, claims are otherwise time-barred. So this is a way for public institutions to say, we're going to set aside statute of limitations, we're going to set aside jurisdictional, you can come to the spoliation panel. But the spoliation panel's remit is limited to World War II. So when the claim was brought, the National Gallery set forth the evidence. They said they're not claiming the painting was taken during World War II. The spoliation panel said, yes, you're right, we can't hear the case. So the plaintiffs filed in everybody's favorite district, the Southern District of New York. And everybody thinks the Southern District of New York is the most friendly district to them because of large constituency, their Jewish community, the extensive development of case law, the favorable demand and refusal rule, rules that say New York state law that you can't get your title to stolen property, and you hear that over and over and over. Okay? But the first case we talked about, Louisiana, that may or may not have been stolen property, you can get good title to it. Okay? So those of you who are out here saying, under American law, you can't get good title. There's no such thing as American law. It doesn't exist. There's federal law, there's state law, there's statutes. There's no American law. In this particular case, they were seeking to get jurisdiction pursuant to the Foreign Sovereign Immunity Act of 1976, which I spent the last probably 15 years of my life litigating in 4, 5, 6 different circuits. Their claim was that this was a taking in violation of international law, given the facts and circumstances under which it was lost. And then when the National Gallery rejected the claim, that was a new taking in violation of international law. The Southern District of New York summarily dismissed the case. We had no conversations with the plaintiffs. I was brought in to replace other New York counsel that frankly didn't want to step before the court and say this and really go on the attack. And he came in, the case got dismissed probably within 6 months. There was somebody who talked about discovery, never got to discovery. And the Second Circuit affirmed it in a summary affirmative. Okay? The point here is utilization of the Foreign Sovereign Immunity Act, another hurdle you have to figure out how to get through. And there are ways to get through it. It's been eroded, but yet kind of strengthened. Next one. A beautiful, beautiful El Greco here that you can see at the National Gallery in Hungary. The history of the Holocaust coming to Hungary is an absolutely horrifying story. Hundreds of thousands of Jewish people killed in a very short period of time, March 1944, when the Nazis came into Hungary and overran it at the end of the war. About 10 years ago, a group of plaintiffs came together, the Herzog family, the Chappelle family, came together. There were, I think, 5 different cases filed against the Hungarian state in the United States for the first time. 2 of them in Chicago in the 7th Circuit, 3 of them in Washington, D.C. When this case broke, the New York Times called it the world's largest unresolved World War II restitution case. It involves 44 artworks. We were asked by the Hungarian state to represent them. I've been doing it now for 10 years. I've probably spent, of the 10 years, I've probably spent 2 of those years in Budapest, working with an international legal team where we delved into the archives in Hungary, worked with Hungarian counsel to understand the history of not only the Holocaust as it relates to Hungary, but what happened after the Holocaust, how reparations were put together, the 1947 Paris Peace Treaty, which most people have never heard of, which was actually the first peace treaty signed after World War II with the ex-belligerent states, we call it. Okay? Germany essentially ceased to exist. We didn't sign a peace treaty with Japan until much later. So the Allies had to do something with Hungary, Finland, Italy, and others. And you've got communism, right, that comes into Hungary. And initially after the war, under the Paris Peace Treaty, there was extensive efforts made to restitute artworks to families. And that, in fact, happened. And at some point, as communism moves on, and as people are taking property out of Hungary in violation of export laws that go back to the 1920s, the restitutions stop. And the Hungarian authorities bring actual legal actions similar to our asset forfeiture actions. Right? To say, wait a minute, you're taking property out of the Hungarian state in violation of Hungarian law, no matter who you are, can't do it. We're going to seize the property. Okay? And they start to take the property back. Okay? So property is given back after World War II, then a separate and distinct taking, okay? And it ends up with the Hungarian state. Okay? And it's there since 1940. Of the 44 artworks, they all came into the Hungarian state somewhere between 47 and early 50s, a couple in the 70s, and others. Okay? In 1976, does everybody remember the Crown of St. Stephen's? No. The Crown of St. Stephen's was returned to Hungary in 1976. The Crown of St. Stephen's, as Hungary is falling to the Russians, okay, because the Allies, we said to the Russians, you take the east, we'll take the west. I've seen documentation where Hungarian agents are writing to their counterparts in the UK saying, please come in. We will leave the west side open. We do not want the Russians coming. Too late. So the United States, the Allies, seizes the crown of St. Stephen's, which is the symbol of power and bringing Christianity to Hungary, brings it to the United States and holds it during the communist era. In 1976, or leading up to that, Hungary decides it needs to start reaching out, getting most favored nation trading status with the West. They enter into over a dozen agreements where they say any property taken during up into 1976, you will no longer make claims against. We're going to put a pot of money, at the time $18 million, give it to the United States. The United States can, it's called the Foreign Settlement Claims Conference. You can make claims there, get your restitution. Okay? Well, it's not dollar for dollar. Most of it's taken up by Standard Oil and other large companies that had it expropriated. But a number of these paintings from the Herzog family are on those lists. So we get those lists, we come through. For 10 years now, we then went through full discovery. And recently, after going up on appeal twice, the D.C. Circuit Court of Appeals ruled that under the Foreign Sovereign Immunity Act, the state, the foreign state, okay, cannot be brought into a U.S. court unless the property that you are seeking, that was taken in violation of international law, is in the United States, in connection, and there's a commercial activity attached to it. So we said, wait a minute, property's not in the United States. The Hungarian state, which actually owns it, has to be dismissed from the case. Right now, the plaintiffs are left with the case against the museums. Well, the museums don't own the artwork. Okay? So where are you going to go? The case is not going to go anywhere. We have another motion to dismiss 10 years later that should be heard or should be decided on at any point in time. Okay? The point here again is you need to understand historical events, treaties, and the like that may impact your case. And if you could turn to the next one. This is the case that I think prompted your fearless leader up here to give me a call. It went to trial in December. Irene was on our trial team. We won the trial. You probably read about it in the LA Times. It was published in probably 100 different news outlets throughout the world. This is Camille Pissarro's Street Scene in the Rain from 1897. The Thyssen-Bornemisza is a foundation in Madrid, Spain. If you're familiar with Madrid, it's on there. They call it the Golden Triangle. There's the Reina Sofia and the Prado and the Thyssen-Bornemisza, which was established in 1993. My son starts high school this next year. He was 6 months old when this case started. Wow. The point is, if you're going to go after a foreign state, or you're going to go after an existing owner, you better be in it for the long haul. When we first started this case, right from the start, we said we want a merits trial. We are willing and ready to go to trial. But we do not believe the trial should be in the United States. We are an agency or instrumentality of the Kingdom of Spain. Okay? We fought jurisdiction and we're still fighting it, quite frankly, for 10 years. But all that while, we were publicly telling our story of how we acquired the work, how we were the rightful owners under Spanish law, how the family had been compensated after the war. Many different legal developments came about during this case. We met with the Department of Justice, the United States State Department, and we advocated an interpretation of the Foreign Sovereign Immunity Act on a cert petition that we filed. We did not get the case to the Supreme Court, but what the Supreme Court did when we filed our petition is sent it to the Solicitor General's office for their viewpoint. When that happens, you go to D.C., you sit in a room with 20 or 30 people on behalf of the United States government that may have an interest in the case. Representatives from the National Gallery, representatives from the Department of Justice, State Department, the desk that covers these issues, so forth and whatnot. And the Solicitor General's job is to articulate the United States' position on the proper interpretation of the federal statute at issue. I couldn't convince them to grant cert so we could challenge the point that Spain did not take the painting. We were not responsible for the Holocaust. Okay? The Foreign Sovereign Immunity Act, in our interpretation, was meant to punish or hold accountable those that commit the violations of international law. The Ninth Circuit disagreed with that and said, no, it doesn't matter who took it. The point is it's about the property. But what the SG's office did was, in their amicus brief, said, don't take cert, but Spain should not be a party to this case. They're a foreign sovereign. The property's not in the United States. The Foreign Sovereign Immunity Act, under this subsection, should be limited to situations when the property is in the United States. And so they advocated and went to the plaintiffs and said, you should dismiss the state. So they voluntarily dismissed the state. Now, unlike the Hungarian case, in which the Hungarian state owns the property, here the foundation owns the property. Okay? So the plaintiff wasn't left with a case without actual objects. Okay? But they were left without the ability to pound the head of the Spanish and say, you've got to step in and do something about this. Well, the Spanish government doesn't own the property. Okay? They're now out. Why was it imperative to push that point? Why was it imperative to get the U.S. government on and get them on record on the amicus brief? Because remember, in the Hungarian case, something that the D.C. Circuit Court of Appeals found that under the Foreign Sovereign Immunity Act interpretation, the foreign state can't be in unless the property is in the United States when you're using the expropriation exception. Well, it took me 10 years to build that legal theory, but I was able to go to the D.C. Circuit and say, look, here's the position of the United States. And when the plaintiffs then tried to get that up on cert, the Supreme Court did exactly as we had hoped. They sent it to the SG's office for viewpoint. Here we are, 10 years later, sitting across from Edward Needler, who's still with the State Department, with the Department of Justice, and we're now two or three administrations, both Republican and Democrat, and I can say to Needler across the table, I see no reason for the United States government to change its position on the interpretation of the foreign state, regardless of who the president is. And he kind of laughed and looked at me and sort of said, well, this president has different viewpoints. But we'll see. They did not change their position, and so the Hungarian case ends up getting dismissed. This case finally gets to trial. The California Holocaust Claims Act, we go after that. We get that found unconstitutional, which we say unconstitutionally extended the statute of limitations. They modify it. The California legislature does, specifically mentioning our case. The case comes back after 2 appeals. By this time, they went through 4 different lawyers. They started with Randy Schoenberg, who you've heard of, who did the wonderful Klimt case, but he got out of this case 15 years ago. They then went to Davis Wright Tremaine, excellent lawyer. Davis Wright Tremaine handling the case there. Got it back alive after we'd gotten it dismissed. They then went to another law firm here in Los Angeles, who I really just loved working with, who decided to turn the case into something it never was. Okay? Now, Spain is said to be an accessory to the Holocaust because we're holding on to this argument. Spain is said to be a criminal act. I started as a criminal defense lawyer. Do not call my clients criminals. Trust me, if there was ever going to be a conversation about resolving things, don't go to the press and say that we're accessories to the worst horror ever put forward. But first and foremost, we were always prepared to go to trial. Ultimately, we did, and we then advocated for the application of Spanish law. Because even if you've got jurisdiction over me, even if you've gotten all the discovery, even if you may have the press on your side, at the end of the day, the job of the court is to apply the law. Okay? And just like the Louisiana court, federal court applied Louisiana state law, here
we've successfully advocated in a conflict of law approach that Spanish law had to apply to establish the property rights. And because of the application of Spanish law, whether or not the property had in fact been taken, which we acknowledged publicly during the war from the family, the fact that the family had received compensation equal to the fair market value of the artwork in 1958 from the successor German government, that they said that didn't give up their property right. We didn't agree with that, but nonetheless that was the ruling. We finally went to trial on the issue of the proper application of Spanish law, and the plaintiffs, now represented by Mr. David Boyd and his law firm, decided to pick up the strategy that the last plaintiff has and said, well, your client knew it. They committed a criminal act by knowingly acquiring stolen property. Okay. Judge wrote a very, very detailed opinion. We presented boxes and boxes of evidence, experts from all over the world, and at the end of the day, the judge said there's no evidence that the foundation of the Spanish government knew the property had been stolen during the war. You win under Spanish law. And then at the end of it, he adds in dicta that he thinks that under the Washington Principles and the Terrorism Declaration, the Spanish government should be doing something to resolve the case. Okay? The case is now going up on appeal for the third or fourth time. But you've got trial on the merits. Okay? So here we see you got all the way there to the courthouse, but you didn't, in front of the case, understand what law was going to apply and how that law applied, so that when you're developing your case, you're developing your evidence, and you're presenting your evidence accordingly, and instead you find yourself, I've got a theory here that got me into court, but it doesn't hold up against the historical evidence. Hence, the paintings in Madrid is displayed as rightful ownership, rightfully owned by the foundation. I think that's one, right? So, again, I really appreciate the opportunity to come and share with you. I think that if I could impart one last nugget, is what the claimant community with the Jewish heritage has done very, very successfully is isolate claims. Find identifiable property that you can make a singular lawsuit about, okay? And go after it in different jurisdictions. And buttress it with a very aggressive media attack. Okay? And you're going to get some home runs. Okay? But their answer is don't be afraid to lose. Okay? We're going to keep going. We're going to keep coming at you. We're going to keep coming at you. I think the other issue you face is the financial value. Okay? Many people think that what I take on these cases from my clients is because the artwork is worth so much money. Remember what I said earlier. They don't carry it as an asset on their books. Okay? It's about the rightful ownership, and it's about the current owner. Did they act properly? Were they as conscientious as they could have been? Did they conduct themselves in good faith? And then what's the applicable law for them? Okay? And understand that they're going to exercise their rights under the law, just like you're choosing to exercise your rights to bring a case in the United States. And my clients expect due process, just like you do. My clients expect to do a discovery process just like you do. I've had the honor of examining Holocaust survivors. I never imagined that would be something I would do when I started practicing law in Wisconsin, but it's no different. You're trying to get facts. You're trying to establish evidence. You're trying to create a compelling story. So thank you for letting me share my story with you. I hope you take something away from it and figure out how to bring a viable case going forward.
So my first thought is our job got a whole lot tougher now. He not only speaks well, but he looks good while he's speaking well. So, joking aside, Thaddeus, he said about St. Jude Thaddeus, if you Google right now, you'll see it also means courageous heart. So he had a courageous heart for having come here to give us the perspective that I think that we should welcome more and more. A different one, not ours, but the one that we're going to be confronting. And we talk emotionally, and I make that mistake a lot. But look what just happened. He said he wanted to get down in the weeds, and he did that physically, but also in his presentation. This is not about, morality and then you're going to win. You got to get down and become experts, and we do, in the fact-finding and the laws, in the jurisdictions and the lawsuits and in the pleadings and everything. So I think it was really insightful, and thank you for that.